any time. Good morning and welcome to today's hearing focused on the Administrative Procedure Act and the rulemaking process. Before we begin, I'd like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would also like to remind all members and our witnesses that guidance from the Office of Attending Physician states that face coverings are required for all meetings in an enclosed space, such as committee hearings, except when actively speaking. I expect all members on both sides of the aisle to wear a mask for the duration of today's hearing. I now recognize myself for purposes of making an opening statement. Congress enacted the Administrative Procedure Act 75 years ago to establish guardrails to ensure that the rulemaking system is open, effective, and accountable. The APA was enacted in the wake of the New Deal, which created new federal programs and agencies to respond to the Great Depression. In the decades since, Congress has enacted landmark legislation to promote the public interest and protect children, workers, consumers, the environment, and society's most vulnerable. These laws ensure that we have clean air to breathe and clean water to drink, that food and medicine are safe, that workers are safe on the job site, and that borrowers and investors do not get ripped off by predatory lenders. In most cases, Congress tasks agencies with implementing these laws through rulemaking, adjudication, and enforcement. Today's hearing is an opportunity to discuss proposals to update the Administrative Procedure Act and other laws to ensure that the rulemaking process is effective, transparent, accountable, and consistent with Congress's intent. Congress has long directed agencies to implement and enforce the laws. It is crucial that our agencies and our rulemaking process are accountable and that they provide real benefits that improve people's lives and make them better every single day. It is equally critical that the rulemaking process aligns with our democratic values. Administrative agencies should not be yet another venue that gives powerful corporations and the wealthy greater access and influence than the public, workers, small businesses, and disadvantaged communities that do not have armies of lobbyists. It appears our current process is struggling in this regard. As Professor Wendy Wagner will testify, and I quote, only about half the rules that affect the public involve at least one public, nonprofit, or other commentator that is not regularly regulated entity. And in proceedings in which a public interest representative does file a comment, that entity is almost always outnumbered, at least twofold, and in some studies, tenfold, when compared to industry comments, end quote. Many corporations are still using the big tobacco playbook to influence and delay action. As Dr. David Michaels will testify, powerful corporations employ a strategy to convince regulators that hazardous products are not so hazardous after all, or at least that there is so much uncertainty that there is inadequate convincing evidence to increase protections for members of the public exposed to that product. It is critical that we address this problem. Delay often directly contradicts Congress's intent when it instructs agencies to keep the public safe and promote the public interest. We must also make sure that Congress does not allow the courts to undo the will of the people. For decades, Congress has directed agencies to implement statutes by issuing rules. However, in recent years, the Supreme Court has begun to threaten to dismantle the system of governance that has existed for 75 years. Conservatives on the Supreme Court appear poised to try to achieve what they have been unable to win support for at the ballot box. In a 2019 dissent in Gundy versus United States, Justice Gorsuch, along with Chief Justice Roberts and Justice Thomas, proposed to resurrect the long-dormant non-delegation doctrine. Justice Gorsuch and his colleagues would invalidate the long-standing practice of Congress directing agencies to implement and execute the laws Congress enacts. This result would jeopardize nearly every federal program enacted under both Democrats and Republicans since the 1930s. As Justice Kagan correctly explained, the logical conclusion of Justice Gorsuch's dissent would require that most of government is unconstitutional. Today's hearing is an opportunity to explore potential paths forward for fixing these and other problems plaguing our rulemaking system. With that in mind, I'm proud to co-sponsor Congresswoman Jayapal's legislation to address many of these issues, the Stop Corporate Capture Act. This important measure will ensure a more accountable, effective, and transparent rulemaking system. It requires greater disclosure and transparency in rulemaking proceedings, creates a public advocate to provide for more robust public participation in rulemaking, and ensures that agency actions to implement and enforce the law accurately reflect congressional intent. I look forward to hearing testimony from our esteemed panelists of witnesses on these matters and their proposals to address problems in our rulemaking system. I now recognize the distinguished gentleman from Colorado, Ranking Member Buck for his opening statement.
Thank you, Mr. Chair. I appreciate the opportunity to review the Administrative Procedure Act and examine ways in which we can better remove obtrusive government regulations from everyday Americans' lives. This hearing raises important issues about the growth of the administrative state and executive overreach in recent decades, and I look forward to learning more from our witnesses today. Precisely why the executive branch is so prone to overreach is a complex question, but there are two primary reasons that can explain it. The first is an inescapable reality of human nature that worried our founding fathers. People consistently aspire to more power. The second has developed over time. Congress has been unwilling to make hard decisions, and as a result has shifted responsibilities over to the executive branch regardless of the constitutionality of such decisions. In more recent history, an allegiance to party over the institution of Congress has sped up this shift. Under President Obama, we witnessed one of the largest expansions of the administrative state in the modern era. By acting as though the Constitution and Congress were merely obstacles to be overcome, he dramatically increased the powers of the executive branch and further relegated Congress to a backseat role, with the Democrats in Congress cheering him on. He was so emboldened by a Congress more interested in partisan wins than constitutional principles that he believed with a pen and phone he could take care of most of his legislative needs. President Trump and Republicans in Congress took important steps to rein in the administrative state following the Obama years. Several measures championed by the Trump administration with bipartisan support sought to increase public input and transparency, streamline online guidance portals, and decrease regulatory burdens on small businesses with limited resources. Republicans in Congress have likewise proposed several bills to restore congressional authority and cut through the D.C. bureaucracy. I am proud to co-sponsor several of these measures, including Representative Kamek's regulations from the Executive in Need of Scrutiny Act, which reestablishes Congress's primacy relative to the administrative state, as well as Representative Fitzgerald's Separation of Powers Restoration Act, which reduces judicial deference to agency interpretations of law. Instead of continuing to deregulate and unleash the American economy as we recover from COVID-19 pandemic, the Biden administration has chosen to revoke the policies Trump implemented in what could be generously described as throwing the baby out with the bathwater. That decision, rooted in a distaste of Trump instead of genuine policy concerns, has real-world impacts for millions of Americans. Already, we have seen what increased regulations on oil and gas companies can do to the price of fuel in America, which has climbed nearly 50% since President Biden took office. In the founder's vision, Congress served as a crucial check on the powers of the executive. Collapsing the separation of powers risks to the American freedoms and brings us closer to 18th century monarchies. Unfortunately, Congress continues to take a back seat to the executive branch, leading to increased regulation and intruding into the lives of our constituents. Congress must reclaim its power and stop delegating its authority to the executive branch. Any reforms to the APA must center on streamlining regulations and limiting executive overreach. I appreciate the chair holding this hearing, and I yield back.
The gentleman yields back. I now recognize the chairman of the full committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman. Since its enactment 75 years ago, the Administrative Procedure Act has served as the foundational law governing the processes and procedures of the federal rulemaking system. The safeguards established by the APA ensure that the public has the right to know about potential regulatory action and the opportunity to provide useful and timely input to improve the rules issued by federal agencies. They also provide the public with due process in rulemaking and require agencies to provide a reasoned analysis for their decision-making. The APA, along with judicial review, places essential guardrails on the rulemaking process to protect the public from arbitrary and lawless agency action. In part because of these features, the APA serves as a quasi-constitution for agency accountability and the rule of law. But many administrative law experts believe that there is significant room for improvement. Today's hearing is an opportunity to examine whether the APA is successfully serving its important goals. Some experts argue that the various legal checks on agencies and the oversight mechanisms that are in place need to be strengthened or streamlined. Other leading scholars have explained that because the benefits of agency action often can be difficult to quantify, agencies have become over-reliant on industry-supplied cost estimates, making it more difficult to issue strong regulations that protect the public. In other cases, the regulatory system has routinely failed to reflect adequately the input of frontline workers or marginalized communities, which are often denied a place at the table during the process. In a complex and evolving world, it is critical that we have an agile and effective regulatory system to address the many challenges we face. That is why I appreciate the efforts of the subcommittee's Vice Chair, Representative Jayapal, to make the rulemaking process more inclusive, accountable, and transparent. Her legislation, the Stop Corporate Capture Act, removes opportunities and incentives for fraud and deception in rulemaking proceedings and eliminates unnecessary bottlenecks that delay important regulatory initiatives. I want to thank Congresswoman Jayapal for her leadership on this legislation. I look forward to working with her, Chairman Cicilline, Ranking Member Buck, and members of the subcommittee on these issues over the course of the next year. Finally, as part of the committee's oversight of the APA, it is crucial that we ensure that federal agencies are accountable, effective, and responsive in ways that materially improve people's lives. The COVID-19 pandemic has demonstrated how important it is that agencies have the tools, resources, and expertise they need to serve the public. I was pleased to see that President Biden issued a memorandum on his first day in office, directing his administration to prioritize modernizing and improving the rulemaking process. The memo explained that regulations that promote the public interest are vital for tackling national priorities, and that streamlined regulatory review is crucial for enabling the government to swiftly respond to many of the pressing issues facing our country. Across party lines, 71% of Americans support strong rules to protect the public, keep our workplaces safe, and protect the environment. It is critical that agencies work quickly and effectively to implement the laws reflecting the policy choices of Congress. I also look forward to working with the President's Permanent Director of the Office of Management and Budget and the Administrator of the Office of Information and Regulatory Affairs to ensure that federal agencies are faithfully implementing the law as well as promoting and protecting the public interest. These are critical roles. I was happy to see that just last week, President Biden nominated Shalanda Young to serve as OMB Director. I urge the Senate to swiftly confirm her and for the President to move quickly to name a permanent OIRA administrator. In closing, I thank Chairman Cicilline for convening today's hearing on this important topic, and I yield back the balance of my time.
The gentleman yields back. I now recognize the ranking member of the full committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. The Administrative Procedures Act is important, and I look forward to our hearing today and hearing from our witnesses. But I will tell you this, what's more important is the fact that the Justice Department continues to treat parents as domestic terrorists. And the fact that the Attorney General hasn't been called back by our chairman to answer our questions when 41 days ago he came in here and misled us, and more importantly, misled the American people, I just can't figure out. I want the committee to understand this. In a 24-day time period, here's what happened. On September 29th, the National School Boards Association writes a letter to the President of the United States asking the President to use the Patriot Act to go after moms and dads. One of the individuals who signed that letter, Ms. Garcia, 2 days later, on October 1st, gets a plum position on a board at the Department of Education. 3 days after that letter is sent to the President of the United States, asking him to treat parents as terrorists, the weekend of October 2nd and 3rd, Tim Langen, the head of the Counterterrorism Division at the FBI, is already having conversations with the Justice Department on how to implement the letter sent from the School Board Association to the President of the United States. So think about that. The head of the Counterterrorism Division at the FBI is already talking about how to implement the memo that hasn't yet been sent from the Attorney General. And we know this because of questioning our colleague, Ms. Stefanik, had of Mr. Langen in front of the House Intel Committee. And of course, on October 4th, 5 days after the letter was sent, we have the now famous memo from the Attorney General where he says we want to send to all 94 judicial districts around the country, every single district. We want a dedicated line of communication for threat reporting on parents, a snitch line on moms and dads. All that happens in 5 days. Now, I've been around government a while, and I've never seen government move that fast in my life. 2 weeks later, October 20th, because of a brave whistleblower, we know about an email sent from the same guy, Mr. Langan, the head of the Counterterrorism Division of the FBI. He sends an email to special agents in charge, FBI agents around the country, saying, put this threat tag, this designation, this label on parents who show up at school board meetings and speak out against this curriculum that they don't want their children taught. The next day, pretty important day, October 21st, the Attorney General comes in front of the House Judiciary Committee and says this, quote, I could not imagine any circumstance where parents are treated as domestic terrorists. The only problem is 24 hours earlier, the head of the Counterterrorism Division had sent out an email saying exactly the opposite, using counterterrorism measures against parents, against moms and dads. And of course, the next day, October 22nd, the National School Board Association, because of the political fallout, they thought it was going to be a political winner. It turned out to be a political loser for them. The National School Board Association withdraws the letter, and they say in that letter, we regret and apologize for the letter we sent on September 29th. All that happens in 24 days. Again, I have never seen government move that fast in my life. Now, those 24 days are just part of the story, though, because the most important part is what happened before September 29th. The most important part is the coordination between the White House and the School Board Association before the letter was ever sent. Here's what we know from FOIA requests, from communications made by Mr. Slavin and Ms. Garcia. Here's what Mr. Slavin said. The White House requested additional information from the National School Boards Association before the letter was sent. And Ms. Garcia said this, quote, the National School Boards Association communicated for several weeks with the White House before the letter was sent. In other words, this thing didn't start. I mean, this is the real story. The National School Boards Association letter wasn't the catalyst for this flurry of activity by the Department of Justice against moms and dads. It wasn't the catalyst. It was just the pretext. It didn't originate with the School Board Association. It started with the Biden administration and with the Garland Justice Department. They were looking for an excuse, looking for a pretext to target, to threat tag moms and dads. And the fact that it's been 41 days since the Attorney General sat at that desk and lied to this committee, and we haven't called him back, I just can't believe it. So, Mr. Chairman, I hope the chairman of the full committee will ask Mr. Garland to come back and answer our questions. Because we have seen this pattern before, frankly. And I know the Democrats all day like to make fun of this, but we've seen this pattern before. We saw this with the Justice Department in the Obama-Biden administration. We saw Mr. Comey and Mr. McCabe. We saw that Justice Department, that FBI used the dossier as a pretext to do what they wanted to do, namely go spy on the Trump campaign. They knew the dossier was garbage, but they used that as the pretext, as the excuse to go do what they already wanted to do. Same pattern here. Exact same pattern here. They get the School Board Association to write the letter, oh, here's our excuse to do what we wanted to do. Go after moms and dads. Because we don't like them objecting to critical race theory being taught in our schools. But you know what? The one thing they didn't bargain for was the fact that moms and dads says, we don't care what you do. We don't care if you try to chill our speech. We don't care if you put a threat tag on us, label us domestic terrorists, use counterterrorism measures from the FBI against us. We don't care. We're going to stand up for our kids. The fallout from this, the backlash from this was unbelievable. And of course, we saw it play out in Virginia. So again, I would just say it's been 41 days, Mr. Chairman, 41 days since the Attorney General misled us, the Judiciary Committee misled the American people. I hope our next hearing, whenever that is, Mr. Garland is in here answering a lot of questions we have. I'm sure the Democrats have some questions too, but the fact that he hasn't been brought back is wrong, and everyone knows it. I yield back.
Just to be clear, so that the record is complete, there are those of us who have reviewed all of these materials and believe that the Attorney General testified consistent with everything that's contained in those documents, but that's for another day.
Would it yield for a question?
I'm certainly happy to yield to the chairman of the full committee.
Chairman yield? I just want to point out that what everyone thinks of what Mr. Jordan said has nothing to do with the subject matter of this hearing.
Matter
the chairman
well
yield?
It is now my pleasure to introduce
Mr. Chairman,
today's witnesses.
Isn't that kind of
our first? Our first witness is David Michaels, a professor at George Washington
Could not
University's
imagine any
Millikan
circumstance
Institute
where
School
parents
of
are
Public Health.
treated as domestic terrorists.
Additionally, he has held numerous
The
posts
day
at
before
other
the
institutions.
Counterterrorism Division of the
Gentlemen,
FBI.
it's out of order.
If you would just yield for 1 second, I would like
I
to
will
respond
not.
to what
I'm
you said.
introducing witnesses. I'll begin from the beginning so everyone can hear it. Our first witness is David Michaels, a professor at George Washington University's Millikan Institute School of Public Health. Additionally, he's held numerous posts at other institutions, including the City of New York Medical School, the Albert Einstein College of Medicine, and the Icahn School of Medicine at Mount Sinai. Professor Michaels also has extensive experience working with executive agencies. He served as the Assistant Secretary for Occupational Safety and Health at the Department of Labor from 2009 to 2017, and as the Assistant Secretary for Environment, Safety, and Health at the Department of Energy from 1998 to 2001. Professor Michaels received a bachelor's degree from the City College of New York and both his master's in public health and his PhD from Columbia University. Today's second witness is Wendy Wagner, the Richard Dale Endowed Chair in Law at the University of Texas at Austin School of Law, where she has taught since 2001. She has held visiting and associate professorships at Columbia University School of Law, Vanderbilt University Law School, and Case Western Reserve University School of Law. Before beginning her distinguished career in academia, Professor Wagner worked at both the Department of Agriculture and the Environment and Natural Resource Division of the Department of Justice. Professor Wagner received a bachelor's degree from Hanover College, a master's degree in environmental studies from the Yale School of Forestry and Environmental Studies, and her JD from Yale Law School. Our third witness is Jacqueline Patterson. Ms. Patterson is the founder and executive director of the Chisholm Legacy Project, an organization that strives to connect Black communities on the front lines of climate justice with the resources they need. Before founding the Chisholm Legacy Project, Ms. Patterson established another organization focused on social justice, the Women of Color United. From 2007 until July 2021, Ms. Patterson served as the senior director for the NAACP Environmental and Climate Justice Program. She currently sits on multiple advisory boards, including the Center for Earth Ethics and the Hive Fund for Gender and Climate Justice. Ms. Patterson holds a master's degree in social work from the University of Maryland and a master's degree in public health from Johns Hopkins University. Today's last witness is Jennifer Mascot, the co-executive director of the C. Boyden Gray Center for the Study of the Administrative State and an assistant professor at George Mason Antonin Scalia Law School. Professor Mascot has also held a teaching position as an adjunct professor in administrative law at the George Washington University School of Law. Before joining the faculty at Antonin Scalia Law School, Professor Mascot served as of counsel at Consovoy McCarthy Park, LLC, from April 2019 to January 2021. Professor Mascot took leave to serve as an Assistant Deputy Attorney General at the Office of Legal Counsel at the Department of Justice. She currently serves as an Executive Committee member on the Federal Society's Separation of Powers Practice Group. Professor Mascot received a bachelor's degree from the University of Maryland at College Park and a JD from the George Washington University School of Law. We welcome all of our distinguished witnesses and we thank you for your participation. I will begin by swearing in our witnesses. I ask our witnesses who are testifying in person to please rise. And I ask our witnesses testifying remotely to turn on their audio and make certain that I can see your face and your raised right hand while I administer the oath. Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? You may be seated. Let the record show the witnesses answered in the affirmative. Thank you again. Please note that your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time frame, there's a timing light in WebEx. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals that your 5 minutes has expired. I now recognize Professor Michaels for 5 minutes.
Thank you. Chairman Nadler, Chairman Cicilline, Vice Chair Jayapal, Ranking Member Jordan, Ranking Member Buck, members of the subcommittee. My name is David Michaels. I'm an epidemiologist and professor at the School of Public Health of George Washington University. I'm honored to have been invited to provide testimony on updating the Administrative Procedures Act, including through the Stop Corporate Capture Act. From 2009 to 2017, I served as Assistant Secretary of Labor for OSHA, the longest-serving administrator in the agency's history. I've also written many articles and 2 books on the use of science in regulation. Public health tragedies, from cigarettes and asbestos to the climate crisis and the widespread PFAS contamination of our drinking water, have necessitated the growth of America's public health and environmental regulatory system. The objective of the laws and regulations and the agencies empowered to enforce them is not only to stop the damage and prevent future harm, it's to maintain and strengthen the free market system. Laws and regulations are the underpinning of our economic system. They define market structure and property rights while attempting to ensure that property rights don't intrude on personal liberties. It's clear that our current system of protecting the public's health, safety, well-being, and environment does not function well. We're in a constantly changing world characterized by the rapid appearance of new hazards and crises that can have significant and potentially cataclysmic effects. We need an agile regulatory system to address many difficult challenges: the climate crisis, COVID-19 variants, environmental injustice, income and wealth inequality, the affordable housing shortage, antibiotic-resistant organisms, the opioid overdose epidemic, and the threats to financial stability posed by cryptocurrency, to name just a few. And we need good research to address these. The science community has long recognized the funding effect. Studies funded by a private sponsor tend to deliver the results the sponsor wants. Recognizing that financial conflicts of interest can influence a study, virtually every scientific and medical journal requires authors to disclose potential conflicts, especially who paid for the study. Published studies are now accompanied by a statement by the authors of sources of their funding and potential conflicts in order to alert readers and regulators to look more closely, knowing that financial interests may have influenced the results. In contrast, the federal government does not require any such disclosures when accepting public comments on proposed regulations, permits, or other actions or documents. The Stop Corporate Capture Act requires that participants in our regulatory system provide conflict disclosures comparable to those required by scientific journals. When I ran OSHA, we asked for the same disclosures from parties submitting technical comments in our rulemaking for strengthened silica and beryllium exposure standards. This helped us identify material produced by conflicted scientists, especially those mercenary studies produced for the sole purpose of delaying or weakening public health protections. While disclosure is a useful step, it's not enough. The deeper problem is the financial conflict itself, since this is what shapes the research. Under the APA, studies conducted by conflicted scientists are still entered into the regulatory proceedings, and agents currently must consider them. The Tobacco Playbook, Manufacturing Scientific Uncertainty about a Product's Harms, is often done by scientists employed by product defense firms whose business model involves producing studies that provide whatever conclusion the client wants and can pay for, generally minimizing their product's harm. In my books, I document how product defense firms have done this dirty work for manufacturers of cigarettes, asbestos, fossil fuels, diesel engines, PFAS, and a long list of other deadly products. The subcommittee should consider amending the legislation to add teeth to the disclosure requirements. If an agency determines a study is irreparably tainted by conflict of interest, the agency should be able to exclude it from the record. The Stop Corporate Capture Act has many other valuable improvements to the regulatory system, including establishment of an Office of Public Advocate and a private right of action for regulatory failures. I strongly support these provisions, and I address them more fully in my written testimony. I applaud your efforts here today, and I look forward to your questions. Thank you.
Thank you, Professor. I now recognize Professor Wagner for 5 minutes.
Chairman Nadler, Chairman Cicilline, Vice Chair Jayapal, Ranking Member Jordan, Ranking Member Buck, and members of the subcommittee, thank you for the opportunity to testify today. As you know, the regulatory state is vital to the healthy function of our government, and the Administrative Procedure Act lies at the very heart of that healthy functioning. Yet, 75 years of piecemeal oversight by the courts, the executive branch, and even Congress has taken its toll on the effectiveness of the APA. Some of these added requirements, particularly those coming from the executive branch and the courts, work at cross purposes. Others are ineffective or even backfiring, and all these problems are longstanding and have been around at least since the Reagan and Clinton administrations. Now, to understand these problems, it's important to contrast what the APA promises to do on paper with what it is actually happening in practice. This vantage point, I think, also highlights the excellent progress Representative Jayapal's bill makes in revitalizing the APA. So on paper, the APA provides procedural requirements that are designed to ensure agencies are held accountable both for their scientific analyses and for their policy decisions. For example, when an agency promulgates a rule, it must first publish its initial proposal for public comments. It must then, by the terms of the APA, consider all of those comments, and if the agency fails to do this in ways that run afoul of the APA, the courts can force the agency to start over again. This process is in fact lauded by a number of administrative law scholars as providing an excellent model for robust democratic deliberation. So that's APA on paper. What is actually happening in practice? I'll identify two problems. First, the design of administrative process is very much concerned with ensuring agencies bring their very best science to the table, but 75 years of implementation has yielded some major cracks in this foundational goal. Foremost among them is the risk of the politicization of agency expertise. There is a long-established practice within most executive branch agencies that position the political decision maker at the apex of all agency decisions, including the scientific record. Thus, while the agency's technical experts may conduct an impeccable synthesis of the available scientific literature bearing on a policy question, the political officials are positioned, if they find it useful to their interests, to edit, change, or otherwise manipulate that scientific record before it is ever made public. They can even select the members of the peer review panels. Second, the APA is designed to hold agencies accountable to the public. Yet, the hodgepodge of judicial decisions and executive branch policies sometimes have the effects today of creating incentives for agencies to behave less accountably and to find ways to work around Congress's requirements set out in the APA. The academic literature is overflowing with examples, and I'll just highlight one. As noted, under the APA, agencies must solicit public comment on their proposed rules, but they need not ensure that the resulting participation includes all affected groups. So, to get the rule through, in fact, some courts actually negotiate those proposed rules with the most litigious groups. Empirical evidence bears out that agencies sometimes negotiate the rule proposals with industry in advance before it's published. We also see, as Chairman Cicilline mentioned, that in about half of the rules that protect the public itself and the public interest groups are nowhere to be found in commenting. And yet all of this is irrelevant to judicial review. To reverse these problems and many more, I commend Representative Jayapal's bill. It provides a much-needed public advocate. It institutes controls on the quality of science used for regulation, and it provides greater transparency over White House review. And that's a small sampling of what it accomplishes, but I think still more legislative direction is needed in this area. My written testimony includes a number of complementary proposals, but the highest priority is for Congress simply to place the burden on the agencies to establish why we should trust their processes, both in terms of their expertise and in terms of their accountability. One thing we've learned over the last 75 years, prescriptive requirements can be worked around and backfire. But general demands for explanation can go a very long way to enhance agency accountability. An agency, for example, should explain how it has firewalled its scientific experts from political pressure. It should explain how public deliberations included meaningful deliberations with all major affected groups throughout the entire rulemaking process. In return, the courts could be directed by Congress to afford the most excellent agency processes greater deference.
Professor Wagner, your time has long expired. We're going to get you with questions and answers if that's.
I am sorry, but I applaud your efforts. I did not see my red lights
There's
go
always
on.
room for applause, so thank you.
Okay, thank you.
Thank you,
I look forward to your questions.
Thank you so much. I now recognize Ms. Patterson for 5 minutes.
Thank you so much, and thank you all for having me and for hosting this critical conversation. Our communities have seen the impact of the outsized influence of corporate entities on rulemaking for environmental regulations. EPA records from 1994 to 2009 found that industry groups held a virtual monopoly over informal communications that happened before proposed rules were publicly available. On average, industry groups engaged 170 times more in informal communications with EPA than public interest groups. These were communications that occurred before any proposed rules were even written. By the time the notices were published, comments from the public were buried in an avalanche of well-funded, heavily credentialed comments from industry insiders and their highly paid allies. Industry groups submitted 81% of the comments during the notice and comment period, compared to public interest groups who submitted a mere 4%. Furthermore, between 2001 and 2011, the Office of Information and Regulatory Affairs, OIRA, met with 5 times as many representatives of industry than with people representing public interest groups. University of Wisconsin at Madison found a strong correlation between interest groups lobbying OIRA and the changes in the final rules that favored those very interest groups. So for us, this is important because the people who are paying the price for a regulatory system that's being governed de facto by polluters include communities who are on the front lines of the health, social, and economic impacts due to underregulated toxic exposure. Communities who are on the front lines of near roadway air pollution from the underregulated combustible engine. Communities and nations disproportionately impacted by climate change due to barely leashed greenhouse gas emissions. And 76,000 coal miners who have died of black lung disease because the coal dust went grossly underregulated. Meanwhile, the average annual compensation of a coal company CEO is $9.8 million. The profits reaped by the energy sector are in the billions as a result of the hamstrung regulatory system that paves the path for the companies to operate without rules that protect public health and well-being. When the public participates in the rulemaking process, it truly makes a difference. We've submitted written testimony and organized 5 multi-state delegations to provide in-person testimony on mercury and air toxic standards, new source performance standards, and beyond. School teachers, nurses, firefighters, community leaders, youth, aunts, aunties, uncles participated in these proceedings. As a result, we had an EPA official in tears as she listened to the testimony of a grandfather from Steubenville, Ohio, with his grandson on his lap as he testified on the air quality he wants for his community and for his grandson. A coal company showed us its stripes as it cut off annual support to an NAACP branch saying, "We only support our friends, and your organization talked bad about coal to the EPA, so you're no longer our friend." And in the end, we saw equity-based changes in the language for proposed rules making on air quality. Government entities are already putting infrastructure in place to ensure that they are truly acting as taxpayer-supported public service. The Federal Energy Regulatory Commission established the Office of Public Participation. The Government Services Agency is engaging in a listening relationship with the NAACP, Centering Equity in the Sustainable Building Sector Initiative. The Federal Emergency Management Agency has established a memorandum of agreement with the NAACP and with the Institute of the Black World. So we know what's possible. For our nation's regulatory system going forward, it literally holds the lives and well-being of the people and the planet in its portfolio of responsibility. So we offer these recommendations. Develop a parallel to the FERC Office of Public Participation throughout our regulatory apparatus. And then the capacity of this office must be significant, including technical assistance providers, community liaisons, popular educators, communicators, and beyond to ensure a robustly successful effort of meaningful engagement and informed decision-making. Make rule language user-friendly. It should not take a law degree to interpret these draft rules. Of the people, by the people, for the people. We must take these words seriously. find the communities that are on the margins, and develop a system with a thorough set of mechanisms to engage those communities. Only the rising tide that builds from the margins inward will lift all boats, with pardon for the mixed metaphor. And finally, develop legislation governing and preventing moneyed interest from having access to rule developers and decision makers. This includes guidelines around industry officers and executives becoming the decision makers themselves by going into elected office and then working in allegiance and collusion with the industry. So I'll close by saying that only with the above can we begin to deliver equal protection under the law. Only then can we begin to dream of the true promised land, one that lives up to the tenet of liberty and justice for all. More details are in my written comments. Thank you so much.
Thank you, Ms. Patterson. I now recognize Professor Mascot for 5 minutes.
Thank you so much, Chairman Nadler, Chairman Cicilline, Vice Chairman Jayapal, Ranking Member Jordan, and Ranking Member Buck and members of the subcommittee for having me here today. I'm Jennifer Mascot, a professor at Scalia Law School, co-lead the C. Boyden Gray Center for the Study of the Administrative State, and currently serve as a public member on the federal agency, the Administrative Conference for the United States. And I'm so pleased to be here today to talk about this very important topic. I'm glad the committee is looking into bringing more rulemaking accountability and transparency and re-examining the Administrative Procedure Act 75 years out. As my written statement talks about, the APA has not been meaningfully changed on the rulemaking procedural side in the 75 years since it was enacted in 1946 as a textual matter, but as a practical matter through various judicial opinions and agency practices over the years. Arguably today, the way that rulemaking works is quite different from the way in which the original text of the APA provided the procedures to occur. And so some of the ways in which practice deviates from the statutory text, Congress could address perhaps by revisiting the APA and either specifying that ways in which agencies can bring more transparency and go back to the original text of the APA, or updating the APA procedures to reflect 21st century practices. Some specific examples are that the APA, for example, provided for a category of formal rulemaking, where parties would have a chance to come and give oral presentation of their views, be questioned, introduce testimony. And in the 1970s, because of a Supreme Court opinion, the bar for requiring agency formal rulemaking has been made so high that as a practical matter, that category of agency action really no longer exists. The Department of Agriculture sometimes uses formal rulemaking, but to the extent that Congress thinks agencies should be subject to more procedures, give more public input, the formal rulemaking category could be expanded. The consequence of the formal rulemaking category being conscripted was that more procedures were put into the informal rulemaking category, which I think today notice and comment rulemaking actually arguably is quite different from the text of the APA as well, which provided really only that agencies provide a written opportunity to provide comments, and agencies provide a statement of basis and purpose in the final rule. And today, as some of my colleagues have noted, as a practical matter, rules are hundreds of pages long, lots of explanation. It can be very unpredictable in the courts which rules are going to be upheld, which are not, and agency practice can be inconsistent across the board. So I would recommend Congress revisit that procedure as well. The final consequence that I think is arguably the most damaging is that because informal rulemaking, notice and comment rulemaking, has become so challenging, agencies have really been motivated to do quite a lot through informal guidance statements, interpretive statements that might be posted on websites, issued as letters, suggesting that maybe an agency will engage in an investigation or bring a charge, and sometimes is taken, I think, as a just threat or concern by risk-averse American families and businesses and individuals and corporations. And so through informal guidance documents, agencies often are significantly impacting the behavior of the American people without having to go through any procedural requirements at all. And so one thing I also think Congress could consider is the Trump administration had several executive orders to address these practices, encouraging transparency in guidance documents, making sure that guidance documents were not imposing new standards, were not being used to issue threats, were not being relied on in adjudication. It also had an executive order requiring agencies to make clear what level of intent would be chargeable in a criminal offense. And so, the President Biden has rescinded those EOs, but Congress, of course, could take legislative action to impose those procedural requirements across the board. I think the reason that the hearing today is so important is because today, as time has gone on, more and more action is being taken that impacts American lives and families and local communities through rulemaking. And so I agree that a very important consideration is bringing more accountability, transparency. I think at the end of the day, less regulation in the executive branch, more policy making by Congress will ultimately be the solution, because as we're seeing today, and I predict we'll see in the question and answer, there can be an awful lack of consensus, questions about how agencies should act, very challenging to figure out how to make democratically accountability agencies that are run by just one individual or one set of individuals. And so the Madisonian model, of course, in our founding document is separation of powers, policymaking in Congress. And so if the courts are not going to require more specificity in legislation, Congress could always decide on its own to revisit the laws that govern agencies and make very clear what the requirements are going to be that agencies have to follow. And bring kind of that separation of powers back to bear, either through the Separation of Powers Restoration Act, the REINS Act, or other legislative proposals on the table. Thank you so much.
Thank you for your opening statements. We will now proceed under the 5-minute rule for questions, and I'll begin by recognizing myself for 5 minutes. Many Americans are taught in civics class that Congress passes a law and that's it. But the reality is that major legislation enacted by Congress that addresses climate change, workers' rights, health care, must also be implemented and enforced by the executive branch to become a reality. To do that, federal agencies go through a process of administrative rulemaking or the creation of regulation that enforces the law. Unfortunately, this has turned into a shadowy process where special interests and big corporations send a bevy of lobbyists to make sure that the rules benefit them. There's limited transparency or accountability in the creation and enforcement of regulation. Little opportunity for the average citizen to combat industry-backed research, meetings, testimony that's too often vying against the public interest. And at the end of the day, allowing corporations and special interests to essentially capture our government with their massive and undue influence on federal agency. Mr. Michaels, as the former Assistant Secretary of Labor for OSHA, you've seen firsthand how companies thwart regulation through funding sham academic studies or powerful lobbying groups. What impact do these instruments of power have on the administrative process, and how does this impact workers? You need to turn your microphone on. Thank you.
Representative Jayapal, thank you for that question. It's a huge impact. The wealthy corporations and wealthy individuals know how to impact the system in so many ways. From the very beginning, where they have lawyers who are preparing documents, they hire scientists to produce studies. They know they have findings that will impact regulation. There's a revolving door, and so they hire very senior administrative officials who then can help them get through regulation. And the most sort of lurid example, which I think everybody's aware of, is that Purdue Pharmaceuticals hired the FDA regulator, essentially, who looked at the opioids that they were producing to then work with them to make sure they could sell more opioids, really leading to this disastrous opioid epidemic. The public doesn't have an equal say in this. I mean, that's exactly the problem. And the agencies are outgunned, as you heard from Professor Wagner, that knowing that they will end up in court, regulators often sort of pull back, or they negotiate with themselves even to protect the agency and to get something through. The result is that our regulations are weaker, they're not protective, and people are paying the price through illness, through death, and through a destroyed environment.
Thank you, Professor. Ms. Patterson, you're an expert in environmental and climate justice, and you've seen how the rulemaking process falls short in considering social equity and environmental regulation. Congress has required agencies to consider a host of industry-friendly economic factors when making rules, but it hasn't done the same for elements like equity and justice. How can Congress address that oversight?
Thank you. So one example is to make sure that we actually do have those avenues for public engagement in this conversation. So as I talked about the Office of Public Participation, and then also really building the capacity of agencies to be able to and through that, in building the capacity of agencies to be able to engage directly with communities. And so communities and public interest groups know the types of mechanisms that we need to have to ensure that we're delivering equity. And they need to be able to be at the table with equal status to be able to put those ideas forward.
Very important, thank you. Professor Wagner, the Office of Information and Regulatory Affairs is responsible for reviewing proposed regulation by agencies, but it's often criticized for having too much control. OIRA instructs agencies to make substantial changes to rules, sometimes delaying the implementation of a regulation altogether. How does Congress work to make OIRA more efficient?
Thank you for that question. Actually, your bill, I think, does an excellent job on that front. First, it suggests that OIRA can't even be involved with an agency rule until the agency checks that rule into OIRA. Right now, OIRA works upstream before the review process. And secondly, your bill requires much more transparency on the nature of the changes. I think it would be even more helpful to know why the changes were made, maybe even put some prohibitions on changes to the scientific record, especially scientific records that have prior been peer-reviewed by expert panels before they hit OIRA. So it could go even further, but I think putting some transparency protections in place that are enforceable would go a long way.
Thank you so much. As legislators, it's our responsibility to restore the public's faith in our government, and my bill vastly improves that process. My time has expired. I yield back, and I now recognize the gentleman from Florida for 5 minutes. Mr.
Thank you, Madam Chair. Ms. Patterson, in Chairman Cicilline's introduction of you, he referenced your master's in public health, and so I want to ask a question about public health. Is there a different chemical composition for vaccines in white neighborhoods as opposed to non-white neighborhoods?
Yes, so my master's in public health does not mean that I have in any way had any access to be able to examine the different compositions of different vaccines that are provided in different neighborhoods. So,
do you have any basis to believe that the vaccines being administered in white neighborhoods versus non-white neighborhoods are different?
I don't have any basis to even begin to evaluate that question because, again, I don't have access to the data, samples, or anything like that.
What about the batching process? Is there something called a white batch of vaccines as opposed to a batch of vaccines that would be intended for non-white people?
Not that I've heard of.
Not that you've heard of. It's interesting, I found a tweet of yours from December 3rd, almost a year ago today, 2020, where you tweeted, "My COVID-19 vaccination plan, go to the whitest neighborhood I can find to make sure my dose comes from a white batch." How should we think about that tweet?
As the humor that it was intended, albeit kind of a dark humor in terms of the reality of the Tuskegee experiments and so forth in our community. And so there was a whole string of commentary that we had following from that about how it was a shame that we even have to think in these types of terms. So that's where...
Well, it would seemingly be more of a shame if we thought in these terms without a basis. And I understand people, put things on Twitter sometimes that are jokes. And I noted in response to your tweet, an account called Urban Dashboard replied, "You have a great sense of humor, but too painful to laugh at that joke." And then you replied, "I know, it's all too painful all day, every day. And as I said, I was barely joking because it's real!" Exclamation point.
Yes, the situation.
So is it real that there's different, because you talked about a white batch, are white batches real?
As I said before, that the reference was putting in context this larger conversation about the differential access to affordable and quality healthcare in our communities.
No,
so it shouldn't be taken literally.
Oh, it shouldn't be taken literally. Okay, well, I guess my question is, you gave testimony today about your concern over the monopolistic sharing of information, about the criticality of the input of public interest groups, about how we have to stop the politicization of agency decisions. Do you think it damages public health, and do you think it damages the credibility of public interest groups like yours when you put out that your personal vaccination plan is to go to the whitest neighborhood so that you can ensure that your dose comes from the whitest batch?
Absolutely not. Because
You don't think
I
that's
didn't.
dangerous? Is that
Absolutely not.
misinformation? So how do I know if a batch is a white batch? If I
Again,
wanted to follow
if
I wanted to follow
asking the
your
question-
vaccination plan and I wanted one from the white batch too, where would I go?
Again, you're being facetious, and I've already responded to the question. And so I'm not going to respond to it again because there's not new information to provide.
Well, do you think that being facetious about race-based vaccination issues is dangerous? Because we have seen data that there are communities of color that are more skeptical of vaccines. And do you think that facetious comments like this are helpful?
So I think that they're important to raise the dialogue about why it is that the people are more skeptical. I think it's important to raise the dialogue about how we can.
I only have a few moments left. So
you're interrupting me.
Yeah,
I'm
interrupting you because I only have a few seconds left.
No, you're asking me a question.
What's the
I'm
most
answering the
important
question,
part of the
and now you're
dialogue
breaking
to
into my
understand
response.
from a white
So
batch?
I think it's not really a legitimate seeking of information when you're breaking in when I'm actually responding to the question.
It's always legitimate to ask witnesses before the committee about their own
But it's not
statements.
legitimate
And
it's not legitimate to
Okay,
interrupt when
do you
someone is trying
regret
to
this
answer the
tweet?
question.
Since it seems to be causing some consternation, do you regret having sent it?
No, because it's causing consternation with you. It caused an interesting and important dialogue that is not one that I'm the only one having, that a number of us are having
I
in
think
our
that
community.
sometimes that dialogue can metastasize into disinformation and can actually harm the people that you say you're here to help. My time's up.
No,
I'll
it
go back.
actually acknowledges the reality of what we all face.
But there's no
Time of the
reality of a
gentleman has
white batch.
expired.
That's just
The
something
time
you
of the
made up.
gentleman has expired. I now recognize the chairman of the full committee, Mr. Nadler.
Thank you. Professor Wagner, I'm particularly concerned that the Supreme Court may resurrect the non-delegation doctrine as a means of undoing the ability of agencies to implement statutes such as the Clean Air Act. Last month, the Supreme Court granted certiorari in West Virginia versus EPA, in which this question will arise. Could you explain what the non-delegation doctrine is and what the resurrection, what its resurrection would do to major legislation that Congress has passed in the last 80 years, and what the stakes are if lower courts begin applying this doctrine?
Yes, thank you, Chairman, for that question. The non-delegation doctrine is a doctrine the courts have pulled out of the Constitution, a few words that Congress shall make the laws, has the lawmaking power. So the courts have interpreted that as requiring Congress to make all laws without being able to delegate broad discretion and delegations to the agencies. As an aside, there's a lot of literature now, particularly two important articles that suggest there's no historic basis for even thinking there is such a doctrine in the Constitution. But putting that aside, over the last 200 years, the courts have only applied the non-delegation doctrine twice in 1935, in fact, I think because it has sort of a flimsy basis. So this is something we've worried about from time to time, but hasn't really come to the fore. So what has happened in Gundy is that we see some conservative justices in their dissent suggesting a whole new test for thinking about when Congress has delegated too much lawmaking power to the agencies. They say that statutes could be unconstitutional potentially if the agencies have more power than simply filling in the details or making fact-finding. So the minute agencies go beyond that, there's a threat. This could be catastrophic, in fact, for the administrative state if that kind of dissenting position became the majority position, because almost, I think the last count I saw was 99% of Congress's statutes would essentially be at risk of being unconstitutional under that theory of the non-delegation doctrine. Hopefully the justices won't go that far, but if I were a member of Congress, I would be very concerned about this new non-delegation doctrine trend, because instead of Congress deciding what its lawmaking power is and how much it wants to delegate policy to agencies, it'll be the courts deciding what Congress's lawmaking power is.
Thank you. And in recent years, Federal courts have begun to challenge longstanding precedent that in cases where Congress has not provided clear direction, courts generally defer to an agency's reasonable interpretation of a statute the agency administers. This is known as the Chevron deference. Chevron was a unanimous decision. After 30 years, why are courts now beginning to question agency deference? And if courts eliminate Chevron deference and decide cases under de novo review, how will that affect the ability of agencies to do the jobs Congress has delegated to them?
Thanks again for the question. I think the question is a really hard one. I unfortunately would probably cite to ideology as the shift in Chevron and the approach to Chevron. As the courts give less and less deference to agencies, we're going to see a lot more litigation against agencies. We're going to see rules come even slower, less protection of the public health, because it's just a feeding ground for lots of litigation. So as agencies lose deference, we will see a lot less protection of the public health than already is the case.
Thank you. Ms. Patterson, prior to an agency issuing a significant rule, the Office of Information and Regulatory Affairs reviews the rule. That review process often includes input from and meetings with affected industry stakeholders. In your experience, is the public, particularly frontline communities and vulnerable groups most likely to be affected by an agency's action, involved and represented during this review process? And if not, how is the absence of these stakeholders likely to affect the rules that agencies issue?
Thank you so much. Yeah, the absence of the stakeholder voice and engagement is impacted by the people making the decisions not having the full understanding of what the impacts are, and therefore the rulemaking not incorporating those very impacts. And so through not having the voice of communities that can speak to the impacts and also speak to what types of remedies actually work for them. And we all know the adage that the people closest to the problems are also people closest to the solutions. Without that input, then again, the rule is myopic. The rulemaking can be myopic and missing those critical voices and analysis. Thank you.
Thank you. I yield back.
The time of the gentleman has expired. The chair now recognizes the gentleman from Louisiana, Mr. Johnson, for 5 minutes.
Thank you, Madam Chair. I want to, at the outset here, thank Ranking Member Jordan for what he said several moments ago, continuing to draw attention to the weaponization of the Department of Justice under Attorney General Merrick Garland. And it is, unlike what Mr. Nadler said earlier, it is directly relevant to the subject of this hearing. There is a theme. The theme is the continued abuse by the executive branch of our constitutional norms. That the executive branch is doing far beyond what is the scope of what it's designed to do, and the agency problem is a big part of that. With regard to this specific subject of this hearing, there's 4 key points that I think just really we need to make. Number one, overregulation harms individuals and families and small businesses and the economy. Federal agencies are now wielding just such a tremendous amount of power that unelected bureaucrats abuse it all the time. They are unelected, they're unaccountable, and that kind of power was never anticipated by the founders of this country. Point number 2, President Biden has revoked, of course, as we've noted, some of President Trump's most significant steps to check the administrative state. In fact, he's done the opposite. And the Biden administration wants to radically expand the administrative state and even allow agencies to act outside their statutory authorization without impunity. The Biden administration's overreach warrants congressional oversight. Point number 3, the modern administrative state presents serious concerns about agencies' political accountability and about preserving individual freedom. Longstanding features of the administrative state conflict with constitutional principles, including the separation of powers between the 3 branches of government. Number 4, finally, Congress really does need to act in this space. Congress should never consider proposals to check the Biden administration, or we should consider proposals to check the Biden administration's progressive vision. This vision they have is that we would have rule by woke bureaucrats. We have to restore congressional authority relative to the administrative state and better shield the liberties of the American people. With that, I wanted to ask Professor Mascot a couple of questions about the APA. Of course, for folks watching at home, the Administrative Procedure Act was passed into law in 1946. Of course, it was in response to President Franklin Roosevelt's New Deal.
And the New Deal, of course, caused the executive branch to balloon with the creation of many new agencies to implement his social and economic programs. The legislation had noble intent, of course. It was supposed to create uniformity across the federal government. It was supposed to include the public in the agency processes and reinforce the role of judicial review of agency actions. But what's happened is really the opposite in many ways. The Supreme Court instituted the Chevron Deference, which we all know, and the APA has allowed federal agencies to largely go unchecked. So, Professor, just a quick question. Can you give us just a quick summary of the separation of powers and non-delegation principle arguments against the Chevron Deference doctrine?
Yes, I mean, the key separation of powers arguments, as you're alluding to, obviously the constitutional structure meant to protect individual liberty is to have three separate branches, each playing a different role. And so the general idea as it relates to the APA and the hearing would be, as folks have talked about, the role of Congress in legislating and setting policy. And that has a very important function, obviously, because the members here, of course, can directly represent electoral interests of families and businesses at home across the country. And so there's not a single bit of action that will ever be able to be taken to bring that level of accountability and transparency and democracy and freedom from single administrative agencies acting in the separate branch of government. The executive branch was meant to carry out the law. And then finally, the Chevron Doctrine, as you've noted, is the question about, on questions of law, when an executive agency is supposed to be interpreting the power that Congress has given to it through a law, who is responsible for making that determination? And so currently, the courts have given deference to the executive branch, which inherently creates a bit of a conflict of interest on the law because the agency carrying out the power is then responsible for determining its scope. And so Congress could take action by clarifying that the actual terms of the original APA, which essentially says that agency action is supposed to be set aside if it's inconsistent with law, is in fact meant to impose a de novo standard review on questions of law and clarify that. And that would, I think, in significant measure bring some accountability. Although, again, I think generally regulation needs to decrease. Federal action in general needs to decrease, but to the extent that it's taken at all, it really should be by the broad representative body, Congress, House, and Senate acting together with presidential signature on laws.
Very good. 25 seconds left. Do we need to completely eliminate the Chevron deference, or is it a more modest reform?
I think Chevron deference does not have a place under the terms of the APA, so I think it should be eliminated on questions of law.
Very good. Thank you for your time. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Maryland, Mr. Raskin, for 5 minutes.
Thank you very much. Some regulatory agencies like the FTC, the CPSC, OSHA, and the EPA have been saddled with so-called hybrid rulemaking statutes that require a more formalized process for issuing rules with hearing procedures and cross-examination requirements that are far more suited to adjudication than rulemaking. Dr. Michaels, you are a leading expert in the field and a constituent of mine that I'm very proud of. Do you think that these procedures should be removed in favor of the usual APA notice and comment rulemaking procedures that have been abandoned for these particular agencies and commissions?
Congressman Raskin, it's a great question and something that's very important that we should be looking at. I don't know about totally abandoning them because I think that hybrid procedure actually gets to some very important conclusions. In OSHA, we have a system where anybody who testifies at a hearing can cross-examine anyone else who testifies. So there's tremendous opportunity to gather evidentiary record. On the other hand, it takes a long time. So I'd like to think about, and I think we should all be thinking about ways to cut down the amount of time necessary to do this, to cut down the analytical requirements. The OSHA law says that OSHA has to show that every regulation is economically and technologically feasible in great detail. Okay. And as a result, it takes many years to issue a standard. The silica standard took 19 years.
Let me ask you, and I'll throw in Professor Wagner too here. Do you think that the current OIRA review process is cost-effective and should be maintained as it is, given the added time that's taken for such review and given the growing criticism that OIRA primarily focuses on reducing regulatory costs rather than increasing regulatory benefits for social efficiency generally? Should OIRA really be assigned a different role than it currently has.
Yes, sir.
Yes, thank you. I sort of straddle the fence there, but I actually think that we wouldn't lose anything if we got rid of OIRA review. Currently, it's not only causing delays and leading to mysterious withdrawal rules, but OIRA is really getting in the details, including changing the science, overriding long, extensive regulatory processes, including expert peer review, and then literally changing the standards like it did in secondary ozone. So, off the cuff, I am not sure we would lose anything by getting rid of OIRA review. The White House should be involved in agency decisions and should interact at some level. It's just not clear to me that it should be through this formalized, extremely controlling, very secretive OIRA review process.
Gotcha. And Dr. Michaels, what do you think?
I agree. I think OIRA can play a useful role. I don't think it should be eliminated. I think we do need an interagency review process, but the Stop Corporate Capture Act includes much more transparency, which in my testimony I address, which is really important. I also think it's worth noting that while OIRA really has been a conduit for special interests to be able to intervene secretly in regulations of the past, I think the current administration is working very hard to eliminate that and to expand OIRA's commitment to not just looking at costs and benefits, which are important, of course, but to looking at equity, justice, distributive effects, and pushing agencies to do that. And I think that's really a useful thing for them to do. Okay.
A lot of statutes are silent on the venue for judicial review of regulatory rules that are adopted. And under the APA, this means that rules governed by particular statutes are often subject to review in a district court chosen by the challenger, which delays the review and, of course, promotes forum shopping. Professor Wagner, since there's no need for an evidentiary hearing in such proceedings, nor for a two-stage review of such rules, would you agree with me that Congress should instead require that all judicial review of legislative rules go directly to the courts of appeal?
I think that's an excellent suggestion. The forum shopping that we've seen over the years leads to terrible inconsistency and lots of complicated district court rulings. So yes, I think that's an excellent idea.
You've written that the notice and comment process has become dominated by corporate interests and other highly resourced commenters. What can be done to address this problem? Is there any thought of having agencies provide assistance to applicants who don't have the same resources to participate in proceedings?
Thank you for that question. I definitely think we should think about subsidies and ombudsmen and proxies provided to major effective groups. As I mentioned in my oral and written testimony, I also think that Congress should simply create incentives for agencies to justify their decision-making processes from beginning to end, that they haven't considered and included all major groups, putting the burden on the agency.
Time of the gentleman has expired. Thank you. The chair now recognizes the gentleman from North Carolina, Mr. Bishop, for 5 minutes.
Thank you, Madam Chairman. Is my mic working? Yeah, okay. I was interested to read briefly. Unfortunately, I didn't get long enough time with the materials from you all to spend much time with them, but it strikes me that there's this multi-layered, potentially undermining of the constitutional structure embedded in the APA, and some of these things, I'm sorry, what's your name at the end, ma'am?
Professor Mascot.
Thank you, Professor Mascot. You've addressed that, and if I sort of collapsed them all, it was you've got concentration of power in legislative, enforcement, and adjudicative power in one place in the agency, as opposed to the Madisonian design that you've talked about, where the founders were careful to separate power and create separate parts of government vying against each other. It insulates a lot of federal policy, maybe the primary generator of federal policy, from Democratic control, because you're separate from the voters. Courts are, to arguably, now, Professor Wagner, I was intrigued by the fact that you say you don't see any, maybe no basis for the non-delegation doctrine to be read in the Constitution, and we probably need longer than I have here to talk about that, but it seems to me, at least there's an argument that courts abdicate their role to say what the law is with regulatory deference doctrines. We've seen it, and I think people probably think of more examples, but presidents increasingly resort to the form of regulatory rulemaking and order issuing mechanisms to ascribe a patina of legitimacy to the most egregious abuses of power. And the examples would be the OSHA vax mandate, at least the Fifth Circuit's view of that. Professor Michaels, I know you've taken a different view in Time magazine, I understand. Or before that, a sort of a recalcitrant President Biden ordering an eviction moratorium extension after the Supreme Court had said it couldn't be done. And then, you go even beyond that to this issue of the fact that if that isn't all bad enough, much agency action now is by informal guidance that isn't even subject to the procedural protections of the APA in making rules, or even in the adjudicative processes. And all of that's very troubling to me. I applaud the fact that we're looking at this, but the other thing that's very striking to me as a relative newcomer here is that sort of the main thrust, as I perceive it, of what the majority's questions have been, what the majority's witnesses have said, is that they want to go further in the sense of being careful to advance some and maybe suppress others in the regulatory input process in order to achieve some notion of justice. Those ideas seem to me, without having had an opportunity, Representative Jayapal, to study your bill yet, to raise questions about First Amendment rights of speech and petitioning the government. So all that's troubling to me. And then I came with them. I was listening to Mr. Gates, and then someone sent me this, and I don't know if it's Professor Patterson or Ms. Patterson. Forgive me, I don't have the witness list in front of me, but I was handed something that was from your appearance at the Racial Capitalism Designs for Energy Transition and the Green New Deal at the Rhode Island School of Design. And in response to someone who talked about a gentleman named Baker, who posed a question about the opportunity of revolution, you answered and you said, I would also agree, and well, although maybe I would say I'm not only opposed to revolution, I'm in favor of revolution, very much so, although NAACP might not really co-sign with that. And I do believe in order for us to truly have liberation, or for us to truly have human rights and so forth, the system isn't going to allow for it fully. And I would love to skip more. I'm thinking I'm getting the essence of it. But you say that you're for changing the state. And so let me leave my time, I think, to you, Ms. Patterson, or Professor Patterson, if that's correct. Pardon me for that. Are you a revolutionary? Do you believe we should dispose of the American state as it is constituted?
When you say dispose of the American state, I'm not sure how to interpret that, but I definitely believe that our system was designed for there to be winners and losers. I believe that it was predicated on this notion of really what we've seen in terms of so much of the power going to people who are seeking profit. And I believe that in order for us to truly have liberty and justice for all, we have to change a system that does have so many pathways for profiteers to thrive, and so little pathways for justice to prevail for frontline communities.
The time of the gentleman has expired. I now recognize the gentlelady from Pennsylvania, Ms. Scanlon, for 5 minutes.
Thank you, Chairwoman. So we're talking about the Administrative Procedure Act, the process by which federal agencies can write and enforce regulations to implement the statutes that Congress passes and serve the public interest. We've talked a little bit about the Office of Information and Regulatory Affairs, or IRA, as its acronym is known. And I wanted to focus, and this is called, I think, sometimes the most powerful government agency that no one's ever heard of. I wanted to focus a little bit on the cost-benefit analysis that is used in our regulatory system, because there's a lot of concern that we're not accurately judging costs and benefits, that it's too weighted to, what are the costs to a corporation, for example, that might be impacted by regulation, and not really thinking about the impact on the public of either regulation or deregulation. So, Dr. Michaels, you mentioned in your testimony, I think you said, just as regulations have costs and benefits, the failure to protect the public's health, safety, and well-being also has costs and benefits, and often The benefits accrue to private parties who are profiting from actions that hurt the public. And so what occurs to me is, for example, if we have a large company dumping into our streams or something, there's impacts there on wildlife, on downstream homes and families and water quality, et cetera. But we don't seem to adequately take those costs into effect when we're doing these regulatory reviews. Can you explain a little bit about how the failure to regulate has costs and provide us with some examples?
Thank you. That's a really important question. We have a system that allows and encourages delay. For the government to step in to protect workers, to protect the environment, they have to go through a long process. It can be extremely long. And as long as that goes on, the regulated parties have no incentive to address the problem. And so those costs to individuals, to the environment, are never even taken into account. When we get to the actual regulation itself, when we try to estimate what's the cost of the regulation, it's often to the polluter or to the corporation. And then the benefits are much harder to monetize, because benefits, what is clean air worth to you to be able to see beyond the smoke, or the emotional impact on the family whose breadwinner has been killed in a work-related accident. We don't say that's one of the, that cost to the polluter, to the corporation, is not considered. So we have a whole system that essentially privileges corporations, polluters, manufacturers of dangerous products over the people who could be affected by their products. And one of the really important points in the Stop Corporate Capture Act is to say we have to start dealing with that. We have to look at benefits that you can't monetize. What does it mean to be able to have a type of animal species which will disappear from the earth? Is that valuable to us? Of course it is, but how much is that?
Well, you said, what is clean air worth? I represent a district where I think 1 in 4 of our kids have asthma, and largely as a result of pollutants in the atmosphere. So it's worth a hell of a lot, both to those kids and their families, but also in terms of the costs to society of treating that asthma, of lost opportunities for those kids. Do you have specific suggestions on what we can do to redress this imbalance in how we assess costs and benefits?
Well, I think the 2 steps that we're taking right now, which first of all, President Biden's memo saying that OIRA should begin to address this, and we expect a memo to come out of OIRA soon, is an important first step. And of course, this legislation, which just raises the issue. But I think we need a public discussion to talk about this. We need people to really talk about what is it worth, can we accept loss of a species or our kids getting asthma, which of course mean a lot more than simply just the cost of going to the physician, which already is a big cost. But what does it mean to have a life where you can't really do certain things or you're always afraid? We don't have good ideas how to monetize that. And maybe we can't put a dollar amount on it, but we have to take that into account and take our regulations more seriously to make sure people have better lives.
Right, and I do think some of the costs are actually readily available, but the focus has been too narrow in our regulatory systems. Okay, I see my time has expired. Thank you, I yield back.
The time of the gentlelady has expired. The chair now recognizes the gentleman from Oregon, Mr. Benz, for 5 minutes.
Thank you, Madam Chair. And my question is really to Professor Mascot, but our systems obviously are becoming incredibly complex, and I'm just going to talk about environmental issues for a moment. In Oregon, our governor decided after our legislature did not pass cap and trade to delegate the institution or the implementation of that particular Green New Deal concept to the DEQ, the Department of Environmental Quality, and the rulemaking began. And there has been some suggestion that this rulemaking is not balanced, and perhaps those large corporations, who, by the way, in this case, are supplying energy to all the ratepayers in Oregon, are perhaps being too aggressive in trying to protect those who they serve. And that perhaps other folks should be invited in, as they are, by the way, to be heard, if you will. It sounds as though from remarks made earlier that there's kind of a demonization of anyone that is corporate. I just want to call out that what I have seen in my years in the Oregon legislature was just the opposite, where we saw corporations doing their best to try to protect against inappropriate means of transitioning from different types of power generation. My question to you is, if this concept of more balanced input that we've heard suggested is to occur, what form would it take? Because what I have seen is those who are charged with providing electricity and energy to our folks, that's their job. And so they show up doing their best to try to make sure these rules that have been delegated after they couldn't get it through a legislature, which happened, I think, also with Rule 111D in this body, or the then president wanted that to happen. What would you suggest be done to convince folks that the public is being heard? By the way, the public is being heard in our state, but we've heard maybe it's not being heard now. So, Professor, what would you suggest?
Sure. Thanks, Congressman. And just, I mean, obviously at the state level, separation of powers principles might be, I think, different states by state, but I think the general principle, the Minnesotan principle, stands true at every level of government in the sense that, as folks have noted, concentrated power does tend to corrupt or at least keep one from being able to see multiple perspectives. So I think it is helpful to have many voices involved. I categorically do not think that the best way to approach that is through trying to shoehorn it into the rulemaking process. I think that the Constitution has provided for all voices, corporations, businesses, families, religious organizations, parents, to be heard through their electoral representatives really in Congress, which is why policy making should be made by legislative bodies, because whether it's the state legislature divided up between local districts or the federal legislature divided up between 435 communities represented across the country, that process is the optimal one for many voices and interests being able to be heard through a representative democracy, and that there shouldn't be necessarily an artificial balancing put into place in the rulemaking process. And I think the challenges that we're hearing from many of the witnesses today with people feeling like they're fairly heard in rulemaking simply is evidence, again, that too much rulemaking is happening at the federal level and in the executive branch, and that it can really be in the best interest of Congress and the American people for Congress, whether it's one of the larger agency organic statutes or the APA itself, to take a close look at recommendations for how to give more clear direction to executive actors about how to carry out power. And if institutionally that seems like it would slow things down or be a challenge, a model like the REINS Act, where the executive agencies do the work of the research, kick proposals to Congress, but Congress then brings its electoral accountability to bear and saying yay or nay through the legislative process, could be one proposal for moving forward.
Thank you, and I appreciate that, and I'm going to yield the last 30 seconds to Mr. Bishop.
I don't know if 30 seconds does it for me. Professor Mascot, let me just, I sort of summed up some of the challenges I saw. Is that an apt summary? And what can you say about the legislation? I don't know if you've seen Representative Jayapal's legislation, but there's some Elizabeth Warren has legislation. I understand it codifies the Deference Chevron, and it does some other things on input. Would you have any views on that, or how that would improve APA or the administrative state?
Well, so to your first question about are we getting at all the constitutional questions, I mean, I do think one underlying, even more threshold question is the level of division of power between the federal government and the state government and local bodies. So I think federal government's a government of enumerated powers, and so everything should be limited. I have not, and I'm happy to take a look after the hearing, had a chance to look at Ranking Member Vice Chairwoman Jayapal's bill. Be happy to do so, but I think
time of the gentleman has expired. Okay. If you want to just, thank you. Gentleman yields back. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald.
Thank you, Madam Chair. My colleagues have discussed many of the problems with the unchecked power of unelected bureaucrats in the federal government. There is perhaps no better example of this than the conduct of the FBI in the Russiagate investigation. This committee spent significant time on allegations that President Trump colluded with Russia. He was ultimately acquitted of these allegations by the Senate. These allegations have been proven to be a sham that wasted years of what could have been spent on more important issues like securing our southern border. DOJ Inspector General Michael Horowitz released a report in December of 2019 that concluded the FBI Trump-Russia investigation was filled with serious missteps and concealed information from the Foreign Intelligence Surveillance Act, FISA Court. Now the Durham investigation has demonstrated that the Steele dossier was widely inaccurate. The Clinton campaign cache, Fusion GPS to draft the dossier as opposition research. I think we all know that now. Fusion GPS relied on information from Igor Danchenko, a Russian who worked at the Brookings Institute. Mr. Danchenko based his information on tall tales from Chuck Dolan, a public relations executive who worked extensively with the Clinton campaign in the past. The whole scheme was a vicious circle that began and ended with the Clinton campaign. The fact that the Steele dossier served as the basis for 2 years of Democrat obstruction needs to be investigated further by this committee. Changing gears, we should also be looking at many of the unconstitutional rules issued by the Biden administration and the executive agencies. The administrative state's powers have encroached significantly on the legislative and judicial branch over the last several decades. It is now common for an agency to write a regulation with the force of effective law, executes the regulation, and adjudicates disputes under that regulation. Consolidating all three federal powers into a single entity. Other ways agencies set policy raise similar concerns. For example, seeking judicial deference to agency views. And due to the broad delegations of authority in statutes and expansive interpretation of the Constitution's Commerce Clause, the founders would likely neither recognize nor bless the modern administrative state. A few months ago, I introduced the Separation of Powers Restoration Act in order to mitigate the abuse of powers by unelected bureaucrats in our federal agencies. The bill would overturn a Supreme Court decision in Chevron versus Natural Resources Defense Council that in interpreting an ambiguous statute, courts should defer to the agency's interpretation. Ms. Mascot, can you discuss how this legislation would help curb some of the executive overreach by the Biden administration that has been discussed here today and restore what I think all would consider better checks and balances to the legislative and judicial branches?
Sure. So, as we've talked about, a lot of the agency statutes that are in play now do delegate broad power to the agencies or have been interpreted that way. And so I think the first thing to do would be to tighten up those standards so it's clear by the text of the statute. But as you say, because, and as your bill, I think, points out, because those standards are already so broad, then giving deference to the individuals who are supposed to carry out the power to interpret what it means can often lead to even greater concentrations of power and less accountability and transparency. And what's interesting actually is the initial Chevron decision was written by then Justice Stevens, and his understanding over the years apparently was that it was not even meant to put into place a new system of deference necessarily, although that's how it's played out over time. I think it's inconsistent the way it's carried out now with the text of the APA, and so the Separation of Powers Restoration Act, I think, would helpfully clarify that the current standard of judicial review or restate or redirect that that court should decide what the law is and make sure that Congress's instructions to agencies on questions of law are more clearly followed and not handed over to the executive branch to interpret and carry out.
Thank you. Thank you, Madam Chair. I yield back.
Gentleman yields back. The chair now recognizes the gentleman from Georgia, Mr. Johnson, for 5 minutes.
Thank you, Madam Chair. In 1984, the Supreme Court unanimously decided Chevron versus NRDC and created a standard of deference that courts apply when reviewing an agency's interpretation of a statute. This standard has been applied numerous times across numerous administrations, although I might add that Republicans tend to want to do reform when a Democratic president and administration is in power. But this standard has been applied numerous times and has been revisited and ratified by the Supreme Court on several occasions. Congress and agencies have relied for over 30 years on the concept of Chevron deference or deference when enacting legislation and issuing rules. Professor Wagner, can you explain the concept of Chevron deference and why it is so important for generalist courts to defer to expert agencies when interpreting ambiguous statutory language?
Yes, thank you for that question. So Chevron does say that if the statute is clear, then the court interprets it. When the statute is ambiguous, then we look to what the agency's interpretation is. And the reason is because those are policy-laden political decisions. And the judiciary is not equipped nor appropriate to decide political issues. So that is the structure underlying Chevron, and why the courts thought it was appropriate that when it comes to policymaking, we would defer to the political branches.
Thank you. Do you think it is healthy that the current Chevron analysis and the body of law under that analysis should remain undisturbed by legislative fiat?
Thanks for that question. I mean, the truth of it is the courts have been all over the map, and many have not followed Chevron at all, nor do they even cite Chevron. I think that the Chevron Doctrine has a great deal of sense behind it in terms of not having the courts meddle with political decisions. So I think having a signal from Congress that is an appropriate way for the courts to review agency decisions would be super helpful, because unfortunately a lot of courts are not applying Chevron deference.
Thank you. Ms. Patterson, opponents of government action often fall back on the narrative that regulations kill jobs or that they hurt the economy, despite evidence to the contrary. How can federal agencies ensure that agency action is informed by actual data and evidence?
Thank you so much. So certainly we should rely on data from even our own agencies, such as the Renewable Energy Laboratory, the National Renewable Energy Laboratories and otherwise, that very much point out the opportunities, even in the Department of Labor, the opportunities in the new energy economy. So recognizing that while we do have a necessary mandate to protect the public and protect our environment on which we all rely for our existence, we also have a mandate to ensure that the economy thrives, and we can do so in the new energy economy. That we know that the solar wind energy technicians is the #1 growing job in the country. We know that solar industry is one of the top 10 growing industries in the nation, and we know that this data exists from our own agencies and otherwise. And so it's really to make sure that we know what that data is, and we also that we're in dialogue with labor and with frontline workers groups to ensure that we know what they want in the path to a new energy economy.
Thank you, Professor. Also, Professor Wagner, in his testimony, discussed how agencies and other parties have found gaps and loopholes around the notice and comment process under the APA, and this can result in agencies essentially pre-negotiating with some stakeholders outside of public view. Do civil rights groups, public interest organizations, and frontline communities usually have access to this pre-negotiation of rules?
Not that I've experienced. That's coming from a civil rights organization and working with multiple public interest groups. As the data that I showed at the beginning, and it's in the written record now, there is such an extreme differential in terms of that access. And so, no, and in short.
Well, to be clear,
the time of the gentleman has expired. The chair now recognizes the ranking member of the subcommittee, the gentleman from Colorado, Mr. Buck, for 5 minutes.
I thank the chair. Professor Michaels, I was looking at your written statement, and on page 11, you quote President Biden's order from January 20th. And there are several factors that you believe should be considered in addition to cost. Am I correct in that? You need to put your microphone on. We're going to have a conversation here. You want to make sure everybody can hear us? Okay.
Yes, sir.
So the one that jumped out at me, and I really don't understand it, is the word equity and the concept of equitable. Professor Michaels, there are 3 professors on this panel today, 3 in this room. Is that correct?
I believe so.
Okay. And the Democrats have chosen on your nameplate to put the word professor. But on the 2 ladies' nameplates, they only have the word Ms. Do you think that's equitable, that the Democrats have discriminated against the women who are professors here?
I'm not sure it's inequitable, but it's certainly incorrect.
Well, okay, but in terms of equity, we want to promote equity, and why would you possibly discriminate against? And I, from their testimony today, their testimony is far more interesting to me than yours, frankly, and I think that we should promote the idea that they are professors, and so I think it's really unfortunate that the Democrats have shown their discrimination, and I think that it should be corrected at some point, that they are professors and we should treat them that way. Professor Mascot, let me ask you something. I think that there are a number of other factors that are involved that President Biden wants the agencies to consider, and one of them is public health and safety. Do you think that defunding the police is part of the consideration for public health and safety?
Well, look, thank you, Congressman. So I'm, here obviously for legal expertise, and so don't have as much on the policy. But I think, generally speaking, that the policy determinations of which factors should be looked at in regulating and in making the law.
I was really asking about defunding the police. You don't want to go with me, do you? I'll ask you another one. How about social welfare? Do you think it's fair for the Biden administration to tell gun owners what kinds of guns they can use to protect their homes and their families? Is that the kind of consideration that the Biden administration wants when he issued this order?
Well, I think that what I was trying to say before is that, no, the Biden administration shouldn't be, I don't think, putting in place any of those factors when it carries out laws by Congress unless Congress has put the factors in itself.
And here's another one. They talk about racial justice. Is it racially just to discriminate against Asian students when they apply to universities or law schools as opposed to other students? Is that racially just?
Well, I agree with your concern about that as well. And again, do not think that imposing a particular view of racial justice should be done by the executive branch.
And how about environmental stewardship? Certainly the fuels that the Chinese use for their energy are far more destructive to our environment and cause more harm in terms of the climate change theory than the fuels in the United States. Do you think the Biden administration would consider that in this memo that they wrote?
I have concerns, as I mentioned before, with the executive branch really doing anything to choose what factors should and should not be looked at in regulations.
I got one more for you. You're going to like this one. It talks about the interests of future generations. Biden administration interested in protecting unborn babies?
Well, again, I think that is an issue that should be dealt with at the state and local level and with legislation and not by the courts taking it off the table or by the executive branch.
I have something from your testimony that you might want to answer more than those couple of questions, but here's one for you. You talk about the Biden administration rescinding different executive orders from the president. One that I'm definitely concerned about as a former prosecutor is the ability of administrative agencies to enact criminal statutes or criminal rules. Any thoughts on rescinding that?
To be honest, I was surprised actually that the Biden administration rescinded it because it did seem to me to be a policy that would have bipartisan support because there is a lot of criminalization at the federal level in general. To impose it by regulation, I think, is challenging. And what the executive order simply did was to say that it needs to be very clear from agencies what level of intent is going to be used to prosecute. And
I
it
thank
seems
you
like
for your
everybody.
question, your answers.
Okay.
I'm sorry, but I've run out of time and I yield back.
The time of the gentleman has expired. I want to thank the gentleman for pointing out the unintended errors on nameplates. We will get new nameplates made and put before us. The chair now recognizes the gentlewoman from Pennsylvania, Ms. Dean, for 5 minutes.
I thank the chair. I thank all of the testifiers. And Madam Chair, and to the testifiers, my absence here is because I'm running between two hearings, so please take it as no indication of an absence of interest in what you have testified to. And I thank you for participating today. Dr. Michaels, I was interested in something that I read in your testimony. You described the Tobacco Playbook, which has had an impact and maintained a grip on American society for decades. In fact, my entire lifetime. Could you please detail the Tobacco Playbook, provide an example of how that is, what it is and what it was, and how it is being used today?
Thank you, Representative Dean. The tobacco industry, with the help of the public relations industry, figured out in the early 1950s that they couldn't say that tobacco didn't cause lung cancer, smoking didn't cause lung cancer, but they could say the science is unclear. And they inflated anything that didn't look like lung cancer being caused by tobacco. So, for example, they put out some pamphlets that say, you know, bald men are at greater risk for lung cancer, which of course I was interested in. But the point is, they would avoid addressing that problem to delay regulation. And that strategy now, that disinformation playbook, is widely used. We see it in climate change, of course, where the fossil fuel companies paid some very marginal scientists to go out and say, no, no, the studies don't say this, they say that. So now we have a whole industry that creates this disinformation, that does strategic literature reviews, and then puts them into the EPA or the OSHA to say, look, we've looked at this literature and it's not right. And as I talk about in my testimony, it can take an agency years to respond to that. And of course, as we talked earlier, you know, delay of regulation has a real cost to the public.
And as a point of personal privilege, my father wrote 60 years ago an article entitled "England Warns Its Youth." So I worry desperately about disinformation campaigns of old and disinformation campaigns of today. Ms. Patterson, what do agencies need to do to make providing input more accessible for frontline communities and other affected groups? You stated affected groups need a seat at the table in your testimony. What concrete steps can we take here to make sure that affected groups have a seat, have a voice against the issue at hand and the rulemaking at hand, as well as against disinformation?
Yeah, thank you so much. First is to really make sure that the information that is being under consideration, that it is put in terms and in forums that are accessible for communities to be able to know what they are weighing in on. So ensuring that we have digestible information and that's in terms of what's being proposed. Before I talked about having concrete mechanisms like an office of participation, public participation and so forth, and therefore making sure that those offices have people that are able to be liaisons, to be translators, to be communicators and popular educators, to be able to reach the communities that need to be able to give this input. And secondly, to make sure that the avenues for providing the inputs are there, that at every juncture that the public, the communities know where they can give input in the same way as I talked about the disparities in the beginning, that at all the junctures, whether it's before something is being written so they can give, you know, input in design, while it's being written so they can give input on process, and then providing input on final drafts. So ensuring that we're really doing an audit of all levels and all pieces of the continuum. So those are some of the concrete examples. Certainly in my written testimony, I gave a little bit more. Go on.
I thank you very much for that. And I'll use the remaining time that I have, maybe with a global question, Dr. Michaels. What would, in addition to what Ms. Patterson just said, what would a well-functioning rulemaking system look like? What concrete improvements can we make from what we have right now?
Well, certainly a level playing field. Right now, wealthy individuals, corporations have a tremendous amount of input, and it just isn't fair. Poor communities, disadvantaged communities, just the regular folks, workers, people who care about their environment have nowhere near the ability to weigh in. And so as long as we have a system that works now, we really need advocates for the rest of us, not just for the wealthy and powerful.
I thank you, and I thank you all for your participation and your testimony today. With that, I yield back.
Gentlewoman yields back. The chair now recognizes the ranking member of the full committee, Mr. Jordan from Ohio, for 5 minutes.
Thank you, Madam Chair. Professor Mascot, when was Dr. Fauci elected to office?
At no time.
Has he ever been elected to anything?
I have not, he's not, certainly not in the current role,
Is he a
but
member of Congress?
no.
Now, you know, Dr. Fauci's a smart guy. In fact, if you don't believe me, just ask him. He said Sunday on a TV show that, quote, I represent science. So I'm not saying he's not a smart individual, but who does Dr. Fauci answer to?
Well, I mean, well, at this point, I mean, presumably indirectly to the president, but I take your point.
Well, I don't even think, Professor, with all due respect, I don't even think he answered to the president, because President Biden says we follow the science, and Dr. Fauci has basically said, I am science. I'm almost like God speaking. So I don't even think he answers to the president. So this is what scares me, is the fact that it's people who've never put their name on a ballot, never went out and talked to we the people who are making the decisions. And frankly, the Democrats' witness likes it that way. Let me just read from Mr. Michaels, Professor Michaels' testimony this morning. Just one sentence. We need an agile regulatory system to address the climate crisis, COVID-19 variants, environmental injustice, massive income, wealth inequality, affordable housing shortage, antibiotic resistance organism, the opioid overdose epidemic, and threats to the financial stability posed by cryptocurrency. We don't need a Congress. We don't need a Congress. We got this regulatory system that the Democrat witness thinks we need. So forget like putting your name on a ballot, going actually out and talking to the people and get elected to office and being in the United States Congress. We don't need it, according to Mr. Michaels.
So
Isn't that your concern?
Yeah, I think you're putting your finger on a very poignant example in current practice where we have a significant problem facing the country, obviously the pandemic. And there's a very broad statute, the quarantine statute from the 1940s, that had not been carried out anywhere close to the way it has been applied recently in the past.
But Mr. Michaels doesn't want to limit it to that. Dr. Fauci may want to. Who knows what he wants to? He probably just wants to be dictator. But Mr. Michaels doesn't want to limit it to that. He talks about affordable housing. He's talking about cryptocurrency. He's talking about environmental injustice. I mean, he's talking about all kinds of things that he thinks the regulatory state needs to be able to agilely, or in some kind of fashion, be able to deal with. So
Yes.
it's not just quarantine issues.
Well, of course, and I think the reason what you're pointing to, right, is the breadth of the law and how it's being interpreted. And if we defer to the executive branch's interpretation, that housing and cryptocurrency and whatever else falls within.
But that's sort of how it works, isn't it? Isn't? I mean, there's always some exceptions, and there's some give and take in the comment period of these. But the agency proposes a rule, then they enforce the rule, and then if there's a dispute, they have an Article I judge, executive branch judge, adjudicate. So again, and they want more of that. They want them to do that for everything. So why do we need a Congress?
Right, the concentration of power, I think, in single entities is one of the greatest problems facing our system of government.
No kidding. No kidding. Some of these people, I mean, the people who make decisions and impact small business owners, Americans, I mean, just every single day, the regulatory state, the bureaucratic state runs this country, and it is a huge problem. It's the biggest threat to liberty I think we see. And I haven't seen the bill that the chairman is introducing, but my gut tells me it probably moves in the direction that their witnesses want it to go, which is more power to the bureaucratic state. Is that your interpretation of their bill? I don't know if you've seen it either, because I haven't.
I have not seen the bill. I will say I think the most constitutional approach would be for power to be dispersed among different decision makers, state, local communities, families, then at the federal level, policymaking in Congress. And you all have a lot of power here to be able to put those systems in place and make policy
We're supposed to have a lot of power, something we need to claim back or take back. This idea that bureaucrats are going to run the country is, as I said before, frightening. You said this earlier. I just want to read this. I think this is you put this well, and you just basically said the same thing. The distribution of power over separate branches of government helps to ensure that each branch can more effectively perform its function of serving as a check on the other branches in order to better secure, this is the important part, the private interest of every individual. The security for civil rights consists in the multiplicity of interests. That is the Constitution. That's what this committee is supposed to uphold. More than any other committee in the Congress, we're supposed to be focused on that. And yet we have witnesses come in here and basically say, do away with Congress, let the regulatory state run the country. That is frightening. I yield back.
Gentleman yields back. I seek unanimous consent to add a number of statements and letters regarding the current state of the rulemaking process and potential legislative reforms. A letter from Robert Weitzman and Jack Gillis, the co-chairs of the Coalition for Sensible Safeguards. A letter from Blake Emerson, assistant professor of law at UCLA's School of Law. An article by David Michaels and Jordan Barab, published by Time magazine, titled "We Ran OSHA, Here's the Truth About So-Called Vaccine Mandate." A letter from James Goodwin, the senior policy analyst at the Center for Progressive Reform. A letter from Martha Kinsella, senior counsel at the Brennan Center for Justice's Democracy Program. The Brennan Center's National Task Force on Rule of Law and Democracy's Proposals for Reform, Volume 2. So ordered. I now recognize the gentlelady from Indiana, Ms. Spartz, for 5 minutes.
Thank you, Madam Chair. I think we talk a lot about corporations here and hiring scientists. I think scientists hired by government are also not less biased, because every scientist, every project I've seen, every report and study usually always pleases the payer. Every government study always yields the result that the government asks them to yield. So I would not really give too much credibility to government-paid studies or a lot of universities where if you want to actually get tenure, if you not publish your work within the small group of people that have their own views, you're probably not going to get a tenure. So there is a lot of subjectivity. And honestly, if you look about, we're replacing right now the real liability with unenforceable regulations, where most of them should be decided in the court of law and not given so much immunity. A lot of it was always joking, a lot of this attorney will be out of business if we continue giving these unlimited immunities. But my question is just a quick question I have for Dr. Mascot. You're a professor of law. I am just an accounting, but when I look at the level of regulation and executive orders that have been expanded to the level, unbelievable, I was shocked to see that actually Congress doesn't have a streamlined process to deal with executive orders, and Congressional Review Act is not applying. So we streamline at least somewhat to look at regulations. Do you believe we need to really do a better job to see how we can deal more effectively with executive orders?
I do think that executive orders at times are being used in ways that they were not originally intended. I mean, the intent of the executive order, of course, is for the president to be able to oversee the executive branch. I think the fundamental problem is that Congress needs to take a greater share of the policymaking power, delegate narrower areas of authority with more detail, and then there would not be as much of an area of discretion within which the executive order would operate.
So just generally, if we make our law less ambiguous, which I really love it, attorneys don't, but I do, so that would help. But is there anything that for us to really to oversee and streamline the process if we do believe that president, and regardless who it is, Republican or Democrat president, overstepping his authority?
I mean, I certainly think in areas of laws, and just start subject matter by subject matter where it's causing the greatest concern, whether it's now with the pandemic or whatever, for Congress to exercise its policy will, and that could be through constraining what the executive, including by executive order, is able to do in areas of domestic policy.
So just define a little bit better what they can do.
Absolutely, much better, yes.
Okay, well, thank you so much. I yielded my time to Mr. Johnson of Louisiana.
Thanks so much, my colleague. The APA is supposed to provide greater transparency and public participation in agency rulemaking, and I'm pleased to hear my colleagues, including the gentlelady from Washington, stress the importance of this principle, especially in the area of healthcare. So I'm a bit surprised that my colleagues on the other side of the aisle all voted for the Build Back Better Act, which waives APA rulemaking and judicial review in more than a dozen places with respect to the regulation of drug pricing. The question real quick is, does any member of the panel believe that significant agency actions like this should be done in the dark, with no notice and comment or judicial oversight, especially with such a significant area in the economy? Anybody? Anybody agree with that? The question is, do the witnesses think that these provisions need to be removed to ensure that the public knows how drug pricing is being regulated and what went into those decisions? Professor Michaels, do you have an opinion on that? Should it be removed?
I can't comment on that since I don't have any direct knowledge of what the provisions are in the Build Back
Okay,
Better
all
bill.
right. How about Ms. Wagner? Any comment on that?
Unfortunately, I also don't know anything about it.
You know what? None of our colleagues know either. There was no discussion about these provisions when the House was considering the bill. I'd be surprised if any member, any of my colleagues, were even aware it's in there. But isn't that why we need greater deliberation and transparency in governmental action? Professor Mascot, comment on that? Thoughts about it?
Well, I certainly think consistent with just the general nature of my comments, and I have not myself seen that particular legislative proposal, but I think the policymaking, when we're talking about imposing new requirements on regulated people and individuals, should be done through Congress.
So just for reference to those who want to thumb through this at home, page 647, page 2000, page 2015, 2020, 2062, 2081, 2114, and 2124. At least 8 places in this bill, it puts it in a dark closet and allows unelected woke bureaucrats to make the rules. I'd yield to Mr. Buck.
I was just wondering if my colleague thought that anyone in Congress had read that bill before it passed, because to my knowledge, we got that bill with just a few hours before we voted on it.
I'm out of time, but I don't think it was possible to read. I yield back.
Expired. This concludes today's hearing. Thank you to our distinguished witnesses for attending. We must curb the undue power of corporations, prioritize the interests of the public, and clear a path for public participation in the law. Legislation like my bill, the Stop Corporate Capture Act, will vastly improve the rulemaking process by increasing accessibility, transparency, and accountability. I look forward to working with my colleagues to address this issue. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. The hearing is adjourned.